Hi, my name is Cynthia, and today's my top 10 tips concerning wills and trusts. I am a retired lawyer. I do not have a license. I'm not giving you legal advice. You can find this on the internet to verify anything I'm telling you. My information is based on Michigan past law, and again, check with every state's different. Check on the internet about your state. But first of all, big difference is wills have to go, have to be filed, once you pass, have to be filed in a court to be executed. Take care of everything that you say in your will. And courts are usually called probate. I don't know what they call it in your state, but in Michigan they're called probate. And there's going to be some cost involved, but they have to be filed. A trust, on the other hand, can be executed within days of your passing. Do not have to go to court whatsoever. The next difference is costs. A will can cost anywhere from $300 up. I don't know, what every lawyer's different. Sometimes you can get them cheaper. If you get on the internet, you probably can get one off the internet and do it yourself. Be careful because you want it to be legal. Well, a trust can cost anywhere from $800 to $3,000 and up. There's reasons why it's a little more expensive, and I'll talk to you in my next tip. The next tip, wills are usually standalone, just a will. If you want to have other documents, sorry about my parrot, there's other documents you really need to get, and patient advocate for covering you if you're disabled and you need somebody to make decisions about your care. And next thing is financial advocate, someone to take care of your finances if you're sick and are unable to sign checks and that kind of thing. Those documents can cost another $100, maybe $300. I don't know what an attorney's going to charge you, but there are additional costs concerning that over the will. While you get a trust, those documents are usually included in the package. So you get all of that in your package with a trust. So it might sound a little bit more money, but it's worth it to have that all included. Next thing, taxes. If you file a will in probate and you transfer real estate, most likely you're going to have to pay tax. Your heirs are going to have to pay taxes on that transfer. Capital gains tax. And capital gains tax in Michigan can be up to 15% based on a person's income who's inheriting the item. So that is something to consider when you do a will. Next, a trust, you transfer property. There's no taxes up to $3-5 million. You got to check with your state and find out what that is right now, but no taxes and a transfer of property, which is really quite nice. Next thing, a will stands alone, a trust stands alone, and nobody, by the way, a will, when you file in probate court, it's a public record. Anybody can go down to your probate court and pull your file and find out all your assets, because when a person files to probate a will, you have to fill out some forms, and it usually has provisions in there what items you have, and you have to indicate, your executor has to indicate the values of those assets. So anybody can find that out. It's a public record. A trust, on the other hand, is totally private. Nobody can find out anything about what you own or what you transferred in your heirs, what you did with it. While on a will, somebody can find out whether you gave somebody something or didn't give somebody something. So if you really are into privacy, trust is the way to go. Next item. Objections. If you in your will leave people out, or you change the amounts that you give to certain other people, like you give somebody less than another person more, that those people can object to what you've done. They can file paperwork in the probate court and object and cause that to cost more money for your executor and make your whole probate longer. Trust, nobody can object. Nobody's ever won an objection. They can file in circuit court, but the judge is going to say, sorry, can't object. And trusts have been around since Paul Henry's day, and nobody's ever won an objection. So if you want to do something with your items that you think somebody might object, maybe a wife of your heir or husband of your heir is going to cause trouble, trust is the way to go, because nobody can win an objection there. Now, do you need to have a will or a trust? You need something. Everybody needs a will at the minimum, because if something happens to you, you need to be able to have your items transferred. If you're married, in most cases in different states, you have to check with a lawyer, but your items pass to your spouse without having to have a will. But if you have no spouse or your spouse is deceased, in order to transfer property, you need at least a will. Do you need a trust? I just gave you some reasons why you need a trust. I have a trust. I think a trust is a way for everybody. I'm single. Even if you're single, I think you need to have one. So you definitely look into having that. Now, another item about a trust versus a will can take anywhere from 3 months to a couple years based on objections that are made, problems that you're going to have appraisals done on the property. So the will can take a long time to go through. Trust, on the other hand, can be done within months, because there's nobody looking over the person's shoulder to determine values of anything, and they can pass the property. Now, on that same token, in determining who's going to be in charge of your will, in Michigan it's called personal representative. I don't know what your state will call it. You got to be careful, but at least there's some supervision. The court will supervise to make sure that those items are transferred according to your will. On the other hand, a trust, nobody's going to know anything about what's going on. And I've had cases, unfortunately, where when you're alive, you're the trustee of your trust, but when you pass, you have an alternate trustee step into your shoes. And you have to be very careful who you set up. And I've had people thought they had somebody they could trust, and that person came in and changed all the heirs, disinherited some, and changed the items that were passed around. So that having a trust can be dangerous for that reason, and you have to be very careful who you put in there as your alternate trustee. And those are some items that for you to think about on wills versus trust. Again, I have a trust. I think it's the best way to go, but it can be expensive, and not everybody can afford to have a trust. I hope you've gotten some tips from this that are worthwhile. If you did, give me a thumbs up. Hope you subscribe to my channel. Come back and visit me. Again, I'm a retired lawyer. I'm not giving legal advice whatsoever, but these are my experiences and feelings based on more than 25 years working in the law field. Come back and visit me. I usually I put out a new video every Monday, so come back and visit me, okay? Bye now.